So before starting of the class, let me talk few words about the exams. Remember, the question paper will be uploaded in the website, that is Kakatiya IAS Academy.com. Kakatiya IAS Academy.com. So that is by 10 o'clock. By 10 o'clock, the question paper will be uploaded in the website. So there is a separate tab of mock tests. There is a separate tab of mock tests. So when you click on this tab of mock tests, you can find the question papers. So I would like the one who is writing exam on online, or the one who want to download the question paper, you can download the question paper from this website. Even the previous exam was uploaded along with the key. Normally the question paper will be uploaded by 10 o'clock on Saturday and the key will be uploaded on Monday. So all the response sheets, that is all the answers that you have marked, you can send it to the mail ID of the institution, that is Kakatiya IAS Academy @gmail.com. Right. So please note this mail ID. It is Kakatiya IAS Academy @gmail.com. You can send your answers. You can send your answers to this mail. Both the questions, both the objective questions as well as your descriptive answers. Right. So normally the descriptive questions on polity, they are printed at the end of objective questions. So first it will be objective questions and followed by the descriptive questions. Right. So all the candidates who are writing answers, you can send your answers through mail. Right. So please don't use WhatsApps. Please send your answers through mail. Right. Only those answers which are sent through mail will be evaluated. So already in the last week, only two students have sent their answers and immediately their responses are given. That is, the evaluated copies are being sent to them. Alright, this is one thing. Alright. So I have seen these kind of comments being posted. So just please take a note of this. The question papers will be uploaded in the website. Alright. Not only this, coming to the notes, the notes will be sent. Right. Chapter wise notes, the topics that we have discussed till today. So we have completed historical background, we have completed salient features, preamble and nature of federation. So on every day you can expect the notes to your email IDs. So please send your email ID right to this emails, or you can send the email ID to the WhatsApp. So the notes will be sent through emails. Alright, this is another point. Alright, next one, I got another comment. The comment is about the questions being posted. Normally, I think every day when I teach a topic, right, in between the topics I am giving the questions, yes or no. Alright, so if you are sincere to the class, if you are attending the class regularly, you can find the questions in between the class. And every day you can see 2 or 3 questions being given in the class. Right. So based upon the topic, based upon the context, right, the questions are being posted. So please do check the questions, right, which are dictated in the class, and write the answers. Right. So coming to the questions which are based upon topics in the class, they are dictated as a part of lecture. There won't be any separate posting of questions in the website or any other platform. The questions are dictated in the class itself. The interested candidates, they can take these questions and write the answers, and you can send the answers either by mail or if it is possible for you to come and give, and you can submit the answers in the institution. All right. So these are the things that I want to make it clear. All right. So I hope you have understood this point. So do well for this exam. So what was the last class? Citizenship. All right. So we have seen different grounds. So we have seen different grounds of acquiring citizenship. Right. Different ways of acquiring citizenship. Different ways of acquiring citizenship. Okay. So already you have seen the citizens who are the individuals who are regarded as citizens of India before commencement of constitution, and even we have seen the grounds of acquiring citizenship after commencement of constitution, that is by birth, by descent, all right, by registration, by naturalization. And the last ground that we are that we should discuss is it is about what do you call incorporation of territory. Incorporation of territory. All right, that is whenever government of India acquires, whenever government of India incorporates any territory into Indian Union. All right, whenever government of India incorporates a territory into Indian Union, and all those people, all right, who are habitating in that territory, all those people who are living in that territory will be treated as citizens of India. So whenever government of India acquires any territory, and if it is admitted into Indian Union, so even the people living in that territory will be treated as citizens of India. All right. So these are different grounds. These are different grounds of acquiring citizenship. Now, what are different ways of losing citizenship? Right? Loss of citizenship. Right? Loss of citizenship. So if you take this loss of, that is how an individual loses Indian citizenship, right? How Indian citizenship is lost. All right. There are three ways. One is renunciation. One ground is renunciation. Second ground is deprivation. Third ground is termination. Third ground is termination. All right. So renunciation, deprivation, and termination. So these are three different grounds. These are three different grounds for losing of Indian citizenship. All right. So let me explain each of these grounds. First one, it is renunciation. First one is renunciation. Here it is a voluntary act. First thing, it is an voluntary act. That means whenever an Indian citizen acquires citizenship of any other country, whenever an Indian citizen acquires citizenship of any other country, in such condition, right, the individual should renounce, that is, the individual should voluntarily renounce Indian citizenship. The individual should voluntarily renounce Indian citizenship. Alright. So this is what you should remember. Alright. So whenever a citizen of India acquires citizenship of any other country, citizenship of any other country, then right, the individual, the Indian citizen or the individual should renounce their Indian citizenship. All right, this is one thing. If the individual fails to renounce Indian citizenship, think that even after acquiring citizenship of any other country, even after acquiring citizenship of other country, if the individual fails to renounce Indian citizenship, then the government of India can deprive Indian citizenship of such individual. That is, government of India can take back the citizenship of the Indian citizenship of that individual. Right? That is what deprivation. The individual will be deprived. The individual will be deprived of Indian citizenship. The individual will be deprived of Indian citizenship. Right? If an individual acquires citizenship of any other country. So, if it is renounced by the individual, well and good. If it is not renounced, then the government of India will deprive. That is, government of India compulsorily, right, it will strip off the Indian citizenship. Right? This is one thing. And termination. Right? So, even without acquiring a citizenship of any other country, if an Indian citizen, right, acts against the constitution, right, if an Indian citizen violates, right, the sovereignty, unity, integrity of the nation, so this can be a ground for government of India to terminate the Indian citizenship. Right? So that is simply whenever an Indian citizen acts against the constitution, whenever an Indian citizen threatens, right, sovereignty, unity or integrity of the nation, the government of India can remove his Indian citizenship. That is termination of Indian citizenship. Think, if an individual is removed of their citizenship, now what they should be called as? A person having no citizenship, a person who has no citizenship of any other country, what they are called as? Can we call them as illegal migrants? Right? So, when he is not a citizen of India, when a person is illegally staying in India, definitely he will be called as illegal migrant. Right? Illegal migrant or alien. Right? So, when they are illegal migrants or aliens, they will be simply deported. They will be simply detained. This took place in 2018. Right? This took place in 2018 when two youths from Bhopal, they have shown disrespect to Indian flag. Right? A disrespect was shown to Indian flag, for which the government of India has terminated their Indian citizenship and they were jailed. Right? So, this practical incident took place in 2018 in Bhopal. Right? So, it is an example. It is an example to show that, right, whenever an individual, individuals, right, disrespects flag, disrespects national anthem, disrespects constitution or violates these said grounds, that is sovereignty, unity or integrity, then it is a condition, then it is a ground for terminating the Indian citizenship. All right. So, these are three different grounds, that is renunciation, deprivation and termination. All right. So, this is how the individuals will lose Indian citizenship. All right. So, now let me talk about this Citizenship Amendment Act of 2019. All right. So, why it has become controversy? So, first let me give, right, the provisions of this the provisions of this act, then the reasons for controversy, controversy. Then I'll talk about the way forward. All right. So first, right, simply remember that this Citizenship Amendment Bill, right, actually this Citizenship Amendment Bill was drafted in 2015. It was introduced in Lok Sabha, it was introduced in Parliament in 2016. So bill was drafted in 2015. The bill was introduced in 2016, and ultimately after debate in both Lok Sabha and Rajya Sabha, the bill got passed in 2019. All right. It was in 2019 the bill got passed, but still, all right, there was no specific date announced for the implementation of this act. Though the law was passed, but still now, all right, there is no specific date announced for the implementation of what you call this law, because there is a kind of controversy, there is a kind of opposition shown by the states on this. Not all the states, some of the states in India are opposing the implementation of Citizenship Amendment Act. That is the reason why the government of India has put on hold the implementation of this act. But the government is very what you call confident of implementing this bill, right? Implementing this law. All right. So if you take the basic provision of this law, this law, that is this Citizenship Amendment Act, provides citizenship. It provides citizenship to the what you call illegal migrants. Illegal migrants, right? Illegal migrants, right, who are religious minorities, of the countries like Pakistan, Afghanistan and Bangladesh. All right, the illegal migrants who are religious minorities of Pakistan, Afghanistan and Bangladesh. All right, so that is Hindus, Sikhs, Christians, Parsis, Buddhists and Jains. Right, so these are the groups which are treated as illegal, which are treated as religious minorities in these countries, right? So, and these religious minorities who are illegally staying in India, right? The one who are living in India illegally, and the one who are right? The one who are at the service of India, that is the one who are working for India, right? The one who are living in India and the one who are working for India, that is the one who are service for India, right? The government of India has decided to provide to provide Indian citizenship to these what you call minorities of these countries. All right. So the condition here is they are treated as naturalized citizens of India, and the condition for providing this citizenship is, right, it is 6 years of stay in India, right? It is 6 years of stay in India. 6 years of stay in India, right? So this is the condition. Normally, right, any foreigner who want to get registered as, remember, these illegal migrants are foreigners according to Foreigners Act of 1946. All right. If you take these illegal migrants, these are foreigners. These are foreigners according to Foreigners Act of 1946. All right. So for a foreigner to get Indian citizenship, the condition is they should stay in India for a period of not less than what you call 11 years. Normally it is 11 years. But what government has done? Government has amended this Citizenship Amendment Act, right, providing only 6 years of stay. For others it is 11 years. But for these people from these countries it is only 6 years. 6 years of stay in India, or the one who is working for India, or the one who is the one who is at service for India. All right. So this is the what you call the main provision. This is the main provision. All right. So that means they should prove that they are staying in India for last 6 years. They should prove that they are minorities of this country. All right. Somehow they should prove. Right. Upon proving, right, they can what you call they can be given as Indian citizenship. Right. Then what about the people who cannot prove themselves? What about the people who cannot prove themselves? Can they be given a citizenship? All right. So for this purpose, this Citizenship Amendment Act, right, it is been what we call it has been connected with National Register for Citizens. National Register of Citizens. So we have the issue of NRC. So about NRC I'll talk separately, but as of now, right, remember that this Citizenship Amendment Act, the Citizenship Amendment Act provides, right, citizenship for these what you call for these religious minorities of these countries, right, who are staying in India for a period of not less than 6 years, right. So this is the basic provision, right. Now coming to reason for controversy. What is the controversy around this? Remember here the citizenship is based upon what? Citizenship is given to religious minorities. That means religion is taken as a condition for providing of citizenship. Alright? Here it is religion that is taken as a ground. Religion is taken as a condition for providing citizenship. If you take Indian Constitution, in our Indian Constitution, do we have this ground of religion? Whether Indian citizenship is provided on the basis of religion? No. Alright? So irrespective of caste, creed, religion, place of birth, right? Irrespective of all these conditions, right? The only condition is the birth and the nationality of parents that we have seen in the previous class, right? So religion is not a ground for providing of Indian citizenship, but here religion, that is faith, is used. Alright, it is faith is used. Alright, so which is one point of controversy. Second controversy is, alright, whether all the migrants, all the illegal migrants are given citizenship. No, only these these religious minorities. That means it is unfair because there is no equality of treatment. Right? There is no principle of equality that is followed in providing of citizenship. So there is a kind of discrimination shown. There is a kind of discrimination shown in providing of citizenship. Alright, that is unfair. Right, unfair treatment of individuals. Alright, whether if you take this discrimination or the other form of discrimination, not only on the name of religion, but even, alright, if you take the conditions for getting registered as citizens of India, whether it is same condition for all the people? No. Except this, others requires 11 years of stay. For them it is 6 years of stay. Alright. So which is again a discriminatory practice. Right. And another point here is whether it is to all the countries. No. It is only few countries, selected countries. So religious minorities of only selected countries are given Indian citizenship. That means India, there is a criticism that the government of India doesn't treat all the countries equally. Alright, so that is what unfair treatment is. Alright, that means the one who cannot prove the the one who cannot prove their stay in India, what will be done to them? They will be deported. So it is these people, right, who are in the fear of being deported. The one, right, who has a fear of getting deported, they are protesting against the implementation of Citizenship Amendment Act. Now, who are protesting? Whether the genuine candidates or the one who cannot prove their stay in India, the one who cannot prove their identity in India. Right? If you can prove your identity, there is no problem, you will get Indian citizenship. If you cannot prove your identity, you won't get citizenship. There are many such people who have migrated from other countries to India. Now it is these people who are protesting against this what we call implementation of Citizenship Amendment Act. It is not in all states, right? Those states where there is high presence of illegal migrants. There are certain states in India. I don't want to name them. I don't want to name the states in this class because as it is live streaming. There are certain states in India where there is larger influx of illegal migrants, right? A larger influx of illegal migrants, right? Who are protesting against the Citizenship Amendment Act as well as what you call this National Register for Citizens. That is, the government of India want to update this NRC in certain states, not in all the states. The government of India want to update this register of Indian citizens. So this register was made somewhere in 1950s, but after that there was no updation of this register. But now, right, because of this illegal migration, because of the challenges posed by illegal migrants, the government of India wanted to update this register, and people are protesting against this register. People are protesting against this updation because they are in a fear. They are in a fear that they cannot prove their what you call identity. So there is a protest against both CAA, protest against CAA as well as what you call NRC. The protests are being raised by the one who are staying in India illegally, the one who cannot prove their identity. If they can't prove their identity, right, they will be sent to detention centers. Thousands of people were sent to detention centers in Assam. Right? Assam is the worst affected state in the country because of the problem of illegal migration. Right? So, in order to control this illegal migration, in order to control the challenges posed by illegal migration, the government of India want to implement this citizenship, want to update NRC as well as implement Citizenship Amendment Act. Right? So this is about the issue of CAA. I think in the previous class we were talking about Ramnath Govind panel. Revati, we were talking about Ramnath Govind panel. So what is this Ramnath Govind panel is about? Ramnath Govind Committee. Ramnath Govind Committee. It is about one nation, one election. The report was sent to what you call President of India. Right? So there are certain recommendations made. That is, they have recommended for what you call simultaneous elections. Simultaneous elections for both center as well as states, and exactly after 100 days there should be local body elections. That means this panel suggests that there should not be much time lag between the general elections and the local body elections. Right? So one is simultaneous elections. Simultaneous elections, all right, and within a period of 100 days, right, of these general elections, there should be local body elections. All right. At the same time, this committee recommended that in case of dissolution of government, that is, whenever government falls down because of passing of no confidence motion, or when there is no majority enjoyed by any political party to form the government. In such conditions, right, the committee recommended elections to be held, right. In case of dissolution, of government, or when no party has majority, all right, then in such conditions, right, the election should be held. Right, by election commission. And another important recommendation is the newly formed government, that is after these elections, will stay in office only for the remaining time period but not for the entire 5 years. Right, the newly formed government will stay in office, will stay in office for remaining time period. It will stay in office for remaining time. Alright, that means it will not get a life of 5 years. So this is what another recommendation. Alright, and here this committee recommended, right, bringing changes to constitution, particularly changes to article 83, changes to article 172, changes to article 324A and article 325. Right. So coming to article 83 and article 172, these can be changed, right, without the ratification of states. That is, a constitutional amendment can be made without ratification of states, whereas article 324A and article 325 of the constitution, 324A, 325 of constitution requires constitutional amendment, right, by constitutional amendment with ratification by states, alright. So these are the major recommendations of what you call Ramnath Govind panel, alright. So it is about simultaneous elections, one nation, one elections, alright. So not only one nation, one elections, exactly within 100 days there should be elections to local bodies, right. In case of dissolutions, election should be held where the newly constituted office, the newly formed government, will stay in office only for the remaining time period but not for 5 years, right. And to implement all these things, it requires constitutional amendments, right, which requires amendments to article 83, 172, which can be changed without the ratification by states, whereas article 324 and article 325 of the constitution, right, which requires constitutional amendments such that they are ratified by the states, right. So this is the issue of Ramnath Govind panel. అర్థమైందా అమ్మా రేవతి, అర్థమైందా? So this is about the citizenship. Take down one question in this regard, alright. Take down one question, alright. Discuss the challenges posed by illegal migrants, right. Discuss challenges posed by illegal migration, challenges posed by illegal migration, challenges posed by illegal migration. On India by using suitable case studies, by using suitable examples, alright. So let us now move to the topic of, see, CAA is about providing of citizenship to certain categories of people, whereas NRC it is a registry of the entire Indian citizens. It is a record of all the people in India. NPR, that is what that is, right? National Register for Citizens, right? And this, what do you call this, registry is maintained and compiled by union government by taking the citizenship study, that is by taking the what do you call study of each and every state, right? So where periodically it is being updated, but in most of the states in India this is not been done, that is there is no periodical updation of this registry, right? Because of which, right, the illegal migrants from Bangladesh who came to India, particularly in the states of what you call Assam, West Bengal and Tripura, right? So they got settled here and they are taking the benefits of the benefits which are given by Government of India as well as the state governments, because of which the local people are being affected. So what is demanded is there should be a revision of this registry. There should be revision of registry so that the genuine people can be recognized and they are being given benefits, and the one who are staying illegally. So unless there is updation of this population registry, right, unless there is an updation of what you call these citizens, right, it is not possible to identify who is citizen of India and who is illegal migrant. And when Government of India started this exercise in Assam, right, in 2019, right, so normally from the list, right, so there were different documents used. Say for example, the what you call the voter list was used, for example, voter list was used, and when this voter list was seen, right, it was found that nearly 40,000 people who are listed in voter list, they are not actually the citizens of India. They failed to prove their Indian citizenship. At least they have not, even they have failed to show any one record, either a current bill or a what you call any kind of bill, either a what you call a housing proof, all right, or a 10th class certificate or anything. So there are 40,000 people who are being identified, right, who are staying in Assam without having any valid proof. Now how can they claim that they are citizens of India? So already they are given Aadhaar cards, already they are given what you call this voter cards, and by using that they have even got their ration. But when it is found that, all right, they came from Bangladesh, but they have failed to prove that they are citizens of India. So there were conditions made. So what you call, they need to prove that they are staying in India from 1967. That was a condition. They should show some kind of evidence. They should show some kind of document that they are staying in India from 1967. And what Government of India has done is, when they have failed to show, they have been deported. They have been sent to detention centers. All their all the benefits that are given by Government of India, they have been taken back, right? So which led to massive protest in Assam and West Bengal. All right, వాళ్ళు ఏదో రకంగా వాళ్ళు ప్రూవ్ చేసుకోవాలని చెప్పింది. అది మీరు 10th క్లాస్ రికార్డ్ వాడతారా, కరెంట్ బిల్ వాడుకుంటారా, హౌసింగ్ బిల్ వాడతారా, మున్సిపల్ బిల్ వాడతారా, ఏదో ఒక విధంగా మీరు ఇండియాలో ఉంటున్నట్టు మీరు ప్రూవ్ చేయండి అని చెప్పింది. They came to India illegally, they have occupied the farmlands, they have occupied the agricultural lands, and because of which the local residents, the native citizens of this nation, they lost their lands, which led to communal violences. The outcome of this is, it led to violences between the illegal migrants and the local people. Right? When their resources are being dragged, when their resources are being enjoyed by someone who is staying illegal in India, how the local people will keep quiet? Right? So there was a much controversy went on. This is the main reason for unrest in Assam. The reason for unrest in Assam, the reason for law and order challenge in Assam is this illegal migration. All right. So there was Assam Accord. So all students Assam Union, right? ASU, all students Assam Union, they have protested against this illegal migration. It is this what we call a youth of Assam, right? Who right in the universities, in the colleges, they protested against this illegal migrants, and because of this, right, there was an what you call, the government of India took measures, right, like updating the this population registry, right. So population registry, NPR, right, it is about a record of the people who are living in that state, right, and government of India is required to maintain this what you call a complete registry of the entire citizens of India. So normally we have this census, caste census, socio-economic census being taken. The purpose of this census is to update this registry. Alright. So normally we have a complete update of all the citizens of India. Right, and it is essential to know who are citizens, and what is the total amount of population, and how many people are staying illegally in India and how many are staying legally in India. Right, it is only then government of India can frame a rational policies. So this data is essential. This data on citizens is essential to make rational policies. If not, what happens? If there is no exact data, if there is no exact what you call data on the citizens, there is an every chance of exaggeration of budgets, there is an every chance of diversion of budgets, there is an every chance of diversion of benefits given to the people. Alright. So government of India, to rationalize this, in order to have a clear picture of the people, the citizens of India, right, it wanted it took the exercise of national population registry, right. But most of the states, right, the states which are opposing the union government, they have not allowed any kind of updation. They have not allowed any kind of updation of this population registry. That is what the controversy between the West Bengal and union government. The same thing was with the states like what you call Punjab, states like what you call even Telangana. They have not what you call accepted updation of registry. They have opposed. These state governments have opposed updation of registry. Right. So Citizenship Act is about providing citizenship, and this NRC and NPRs, it is about maintaining the record of what you call citizens and population. Right. So one is the registration, one is the record of entire population, one is the record of citizens. So this is about take to the, so have you took the question? Have you took the question? Alright, that is the issue about, the question is about challenges posed by illegal migration on India by using some example. That is, use examples to give this. Use the examples. Alright, okay. So let us now move towards the topic of fundamental rights. The next chapter, that is fundamental rights, that is mentioned in part 3 of Indian Constitution. It is part 3 of Indian Constitution. So part 3 deals with it, right, fundamental rights, right. So which are inspired by American Constitution. These fundamental rights, they are inspired by American Constitution. They are inspired by American Constitution. Okay. Alright. So we have the particular people like NRAs, right, persons of Indian origin. Alright. The one who is holding the status of overseas citizens of India. Alright. So if you take, let me talk about persons of Indian origin, PIOs. Alright. So if you take these PIOs are those people who have born to Indian parents, who have a lineage to Indian parents. That is, the one who have born to Indian parents, or their grandparents might be Indians, or their great grandparents might be Indians. The one who has born outside of India, either to Indian parents, or whose grandparents are Indians, or whose great grandparents are Indians, they are called as persons of Indian origin. Right? What government of India has done is, the government of India has allowed Indian citizenship to PIOs. Right? The PIOs, they can get registered as citizens of India. So in the previous class I have mentioned these conditions. Right? That is under according to Citizenship Act of 1955. Right? The PIOs are eligible for getting registered as citizens of India. That is what PIOs. Alright, NRIs. Alright, so non-resident Indians. Right? So the Indians who are residing in other countries, right? They hold Indian citizenship. They are citizens of India but living in other countries. Alright, that is, they are those people who doesn't hold the citizenship of other countries. They are Indian citizens, right, without having citizenship of other countries normally. Right? That is, they are non-resident Indians. So they have every right as that of citizens of India. Alright. Now coming to overseas citizens of India. Alright. So the one who holds dual citizenship normally. Right? So they are citizens of India, at the same time they are also other citizens. Alright. So all this categorization made from 2005. Before 2005, we don't have this kind of categorization. The government of India started giving certain voting rights to these what you call PIOs, right, who are registered as Indians, right, and there are certain benefits given to these OCIs. The only purpose of these things is to attract investment from all the Indians who are staying outside of India, in order to ensure the economic development of the nation. Still I remember those days because I was writing my mains exam, right. So when it was on January 9th, 2005, right, it was on January 9th 2005, the government of India has announced this, right. What is specialty of January 9th? Why the day is celebrated as, why it is celebrated as Pravasi Bharatiya Divas? Normally it will be a 3-day festival, 9, 10, 11. It was on that day Mahatma Gandhi came to India. So in order to commemorate that day, in order to remember that day, it is celebrated as Pravasi Bharatiya Divas. Right? It was on that day. Still I remember when I was writing my first mains exam. Right? So this was an important issue. Right? The government of India has announced these kind of benefits. Right? So coming to fundamental rights, which are mentioned in part 3 of Constitution. So here first I'll talk about the basic features of these fundamental rights. Right? Then I will talk about the issue of restrictions on fundamental rights. Then I will talk about the issue of amendability of fundamental rights. So these two are very, very important. So I will discuss them by using the judgments given by Supreme Court. Alright. So first let me talk about the features of fundamental rights. Right. So they are regarded as basic rights of the Constitution. They are called as basic rights of the Constitution. Why they are called as basic rights of the Constitution? What is the reason for calling them as basic rights of the Constitution? Because it is these rights which are essential for the individuals. Right, to grow and develop. Right. So these are the rights which promotes growth and development of individual. It is these rights which promote healthy development, which promotes healthy well-being of individuals. Healthy well-being of individuals. Alright, it promotes individual good. These rights are aimed at promoting individual good. Their basic aim is to promote the individual good, the individual well-being as well as individual good of the people. Alright. Similarly, these rights are always given primacy. They are given importance over all other parts of constitution. That is, part 3 is given primacy. Part 3 is given importance over other parts of constitution. Alright, so part 3 is given primacy over other parts of constitution. Part 3 is given primacy over other parts of constitution. That means in case of conflict between part 3 and other parts, particularly there was a debate arised between part 3 and part 4. When there is a conflict with part 3, right, part 3 is given importance, right. So there was a debate over the conflict between part 3 and part 4 of Indian Constitution, alright. So Supreme Court in Minerva Mills versus Union of India case, Supreme Court in Minerva Mills versus Union of India case, Minerva Mills versus Union of India case. It was in this case Supreme Court has given, clearly said that primacy is given to part 3. Primacy is given to part 3. That means in case of conflict, it is part 3 that prevails over part 4. In case of part 3, in case of conflict, part 3 prevails over other parts of constitution. Alright. So these fundamental rights, they are guaranteed. These fundamental rights are guaranteed. Right. And this guarantee is in the form of constitutional remedies. This guarantee is in the form of constitutional remedies. Remember, these remedies are mentioned in Article 32 of the Constitution. These remedies are mentioned in Article 32 of the Constitution. Not only Article 32, but even Article 226 of the Constitution. So remember, the remedies are mentioned, the constitutional remedies are mentioned both in Article 32 as well as Article 226 of the Constitution, right, which are in the form of constitutional writs, right. So if we take Article 32, there are writs of habeas corpus, mandamus, prohibition, certiorari, quo warranto, habeas corpus, mandamus, prohibition, certiorari, quo warranto. These are 5 types of writs which are mentioned in Article 32 of the Constitution. Right? The ultimate purpose of these writs, is to protect the fundamental rights, is to safeguard the fundamental rights. That is the reason why Article 32 is regarded as bulwark of Indian Constitution. Article 32 is regarded as bulwark of Indian Constitution. It is regarded as bulwark of Indian Constitution. It is termed as, right, B.R. Ambedkar termed this Article 32 as heart and soul of Constitution. It is termed as heart and soul of Indian Constitution. It is termed as heart and soul of Indian Constitution. Alright? Alright? That is what you call the importance of Article 32. That is, ultimately it is Article 32. Ultimately it is Article 32 that is aimed at, it is Article 32 that is aimed at what you call protecting the fundamental rights. Right? So there is a constitutional guarantee, there are remedies, right, to protect the fundamental rights. That is the reason why we regard these fundamental rights as justiciable rights. Right? We regard these fundamental rights are justiciable rights. Right? They are justiciable. So these fundamental rights are justiciable. Don't think that rights are mentioned only in part 3. Don't think that rights are mentioned only in part 3. Remember, rights are also mentioned even outside of part 3. There are rights which are in other parts of Constitution also. The best example is part 4. So what is part 4? It is directive principles of state policy which imposes a moral obligation on the state. Remember, they are not just a moral obligation on the state. Right? These DPSPs, they are not just moral obligations on the state. Remember, these DPSP are non-justiciable rights of individuals. That means these provisions mentioned in part 4 of the Constitution, they act as non-justiciable rights. So we have both justiciable rights as well as non-justiciable rights. Right? So the difference between the rights mentioned in part 3 of the Constitution and other parts of the Constitution, right, the difference between the rights mentioned in part 3 and other parts is, right, the rights of part 3 are constitutionally guaranteed, they are constitutionally protected. That is, there is a constitutional remedy for violation of the rights mentioned in part 3, whereas for the rights which are outside of part 3, the rights which are in other parts of Constitution, there is no constitutional protection. They are legally protected. They are legally protected. Right? So, that means what? In case of violation of fundamental rights, the affected individual, that means the individual whose rights are violated, they can go to courts and claim remedy. Right? The individual whose rights are violated, they can go to courts and claim the remedy. Whereas, and going to courts for the enforcement of fundamental rights, going to courts for the purpose of enforcement of fundamental rights, it is itself is a right. Going to court itself is a right of the individual, which is given by Article 32 as well as Article 226. So both these articles, both these provisions, they provide a right for the individuals. They provide a right for the individuals to move to courts and seek remedy for implementation of fundamental rights. That is the reason why this Article 32 is regarded as bulwark of Indian Constitution. It provides a right, and ultimately the responsibility of enforcing fundamental rights, it is given to whom? Supreme Court. Supreme Court has the ultimate responsibility. Right? It is Supreme Court. It is Supreme Court which has the ultimate responsibility of enforcing the fundamental rights. So Supreme Court is regarded as guardian. Supreme Court is regarded as guardian of fundamental rights. Supreme Court is regarded as guardian of fundamental rights. That means these fundamental rights are enforceable. They are enforceable in a court of law. They are enforceable in a court of law. Alright, that means the individual, the affected individual can go to courts and can seek the remedy. Alright, this is what another important feature. Alright, they are enforceable. Alright, but remember, this guarantee or the remedies, they are available only against arbitrary acts of the state. Right, whatever guarantee or whatever protection that is given, it is available, the protection is available. Alright, the protection is available only against, the protection is available only against what? Arbitrary acts. Only available against arbitrary acts. So what do you mean by arbitrary acts? What do you mean by arbitrary acts? Not following the, so all those acts which are against a law, particular law, or which are without a law, acts of the state. Whenever state acts without a law, whenever state acts against a law, that means whenever government violates law for the purpose of restricting fundamental rights, then the individual can claim protection. Alright, so protection is available only against arbitrary acts of the state. Alright, so that is, this protection is available against unlawful, the protection is available against unlawful acts of the state. The protection is available against unlawful acts of the state. Alright, so that is what. That means whether an individual can claim protection for lawful acts of the government. Think that whenever government acts, whenever state acts lawfully, lawful acts of the state. Alright, whether the protection, whether these constitutional remedies can be used against these lawful acts, yes or no? No. Alright, so always make a difference between lawful acts and unlawful acts. Protection is available against what? It is available against unlawful acts, but not for lawful acts. ఎప్పుడైతే గవర్నమెంట్ చట్టబద్ధంగా వ్యవహరిస్తుందో, ఎప్పుడైతే గవర్నమెంట్ చట్టబద్ధంగా ఉంటుందో అప్పుడు ఎలాంటి ప్రొటెక్షన్ ఉండదు. రైట్, వెనెవర్ గవర్నమెంట్ యాక్ట్స్ అగెయిన్స్ట్ టు దిస్ లా, వెనెవర్ గవర్నమెంట్ అన్లాఫుల్లీ violates fundamental rights, it is only in that conditions, right, it is only in that conditions the individual, the affected individual can move to courts and claim remedy. Am I clear? Alright, so this is one thing, this is one element. Coming to another point. Alright, remember, these fundamental rights are not absolute in nature. Alright, so they are not absolute rights. They are not absolute rights. They are not absolute. That means what? These rights can be restricted. These rights can be restricted. Alright, so the state has every power. The state has every power to impose. State has every power to impose what kind of restrictions? Reasonable restrictions. State has every power to impose reasonable restrictions. Reasonable restrictions can be imposed on the fundamental rights of the individuals, and the power is given to the state. Alright, now Who will say whether the restrictions are imposed, whether the restrictions imposed are reasonable or not? Who will judge whether the restrictions imposed are reasonable or not? Parliament. Now I want even the one who is in online, please give the answers. Alright, please give the answers. So it should be, because I always enjoy an interaction with the student. Alright, whether Parliament will judge. It is judiciary. It is judiciary. Supreme Court. Just now I said that Supreme Court is the ultimate guardian, the watchdog of fundamental rights. So every restriction that is imposed on the rights of individual will be called as reasonable or not by Supreme Court. That is, the judiciary has every power. Judiciary has every power to examine. Judiciary has every power to examine the restrictions imposed on the rights of individuals. Examine the restrictions. Alright? That means there can be judicial review of, there can be judicial review of what? Judicial review of restrictions imposed. There can be judicial review of restrictions imposed. So here in this regard, I want to mention one point, that is Article 13. I want to specify about Article 13. Article 13 says that every law that is made by state, to restrict fundamental rights or to amend fundamental rights, simply any law that is made by Parliament should be consistent with the Constitution. Right? So Article 13 deals with consistency. Consistency of laws. Any law that is made by Parliament, should be consistent with the Constitution. Alright? Now who will check these consistencies? Who will check whether the law is consistent or not? It is by judiciary. So it is judiciary led by Supreme Court. Supreme Court has every power. To check whether the law that is made by Parliament is consistent or not. Alright? So it is the judiciary which is given the power under Article 13. So it is this Article 13 which has conferred power on Supreme Court to review the laws made by Parliament affecting fundamental rights. That means the concept of judicial review. Is within Article 13, or simply we can say that Article 13 is the basis for judicial review. Alright? So judicial review is an implied meaning of Article 13. Alright? So these fundamental rights are not absolute, they can be restricted. The state has every power to impose reasonable restrictions. The restrictions imposed, whether they are reasonable or whether it is reasonable or not, will be examined by judiciary. That is, Supreme Court has every power to review these restrictions. So this was clearly said by Supreme Court in A.K. Gopalan versus State of Madras case. Alright? So it was in A.K. Gopalan versus State of Madras case. A.K. Gopalan versus State of Madras case. It was in this case, Supreme Court upheld its power of judicial review. The concept of judicial review in India for the first time was brought and upheld in this A.K. Gopalan versus State of Madras case. Before this case, the concept of judicial review was not in debate. It was in this case for the first time the Supreme Court upheld its power of judicial review. That means judiciary has every power to review the acts of executive. right, as well as legislature. All right. So, but in the coming classes, that is in the next discussion, I will be more clear about these reasonable restrictions, because it is a separate debate in our class. So, these fundamental rights can be restricted, there can be reasonable restrictions imposed by the state. All right. So, on what grounds, when there can be restrictions imposed on fundamental rights? The issue is when there can be restrictions imposed restrictions can be imposed on fundamental rights. Right. So, in the previous class, right, we have article 19. In our article 19, in article 19, there are specific grounds mentioned, right, for enjoying the fundamental rights, particularly the freedoms of individual, right. So, if you take, let me give this article 19. Article 19 provides specific freedoms, right. Article 19(1) provides specific freedoms. Specific freedoms are mentioned in article 19. All right. Not only we have these specific freedoms, but if you take this article 19 class 2, it also contains what you call the conditions. It also contains the conditions for using that freedoms. All right. Article 19 class 1 contains specific freedoms, whereas article 19 class 2 contains the conditions. It contains the conditions for using that freedoms. Okay. So, this is right. So, this is what you call the conditions. These conditions include, right, sovereignty of India, protecting sovereignty, unity, integrity, public morality, public decency, contempt of court. So, these are the conditions mentioned in article 19. So, violation of any of these conditions, violation of sovereignty, unity, integrity, public morality, right, public order, decency, right, violating the orders of the court, that is contempt of court, all these are the conditions, all these are the grounds for restricting the rights of individual. That means the fundamental rights of individual can be restricted. The fundamental rights of individual can be restricted, right, when these conditions are violated. So, when there is an imposition of what you call martial order, whenever there is an imposition of martial law, simply we call it as section 144. All right, that is what you call, what is section 144 called as? The common term. All right. So, what is the common term that is used in news and newspapers? Section 144 section. All right. So, which imposes restrictions on the free movement of individuals. Even this section 144 was imposed during the pandemic times. People are not allowed to come. All right. People are not allowed to gather. All right. So, whenever normally this section 144 or martial law is imposed, whenever there is a disturbance to public order, right, when there is a disturbance to public order, all right, or when there is a disturbance to public health, all right, these kind of laws are imposed. So, in these conditions, right, there can be restrictions on the rights of individuals. The rights of individuals can be restricted on these conditions. Apart from this, the fundamental rights can be restricted during national emergency, right. So, not only when there is a violation of these conditions, but even whenever a national emergency is imposed, even this, right, then the rights of individual can be restricted. So, there are two articles, one is article 358, and the other one is article 359, right. So, both article 358 and article 359, they deal with They deal with restriction of fundamental rights. They deal with restriction of fundamental rights during national emergency. Whenever a national emergency is imposed, whenever a national emergency is imposed, during these conditions, during these national emergency conditions, right, restrictions can be imposed on rights of individual. According to Article 358, according to Article 358, right, whenever a national emergency is imposed, right, the rights mentioned in Article 19, the freedoms mentioned in Article 19 will automatically suspended according to Article 358. That is, Article 358 says that the rights which are mentioned in Article 19, the rights that are mentioned in Article 19 will automatically suspended. They will automatically get suspended. That means what? They are automatically suspended. That means what? No law is required, no order is required from anyone, right? The Constitution itself automatically limits Article 19 whenever a national emergency is imposed. So, whenever a national emergency is imposed, the rights mentioned in Article 19 are automatically restricted. Okay, that is, they are automatically suspended. Apart from Article 19, right, President of India by an order, President of India by an order can suspend any of the fundamental right. President of India by an order can suspend any of the fundamental right. President of India by an order can suspend any of the fundamental right except the rights mentioned in Article 20 and Article 21. Right? So, President of India by an order can suspend any of the fundamental right except the rights mentioned in 20 and 21. Except the rights mentioned in 20 and 21. Then what about Article 32? Article 32 is also a part of fundamental rights. Right? Whether Article 32 can be suspended or not. The writs mentioned in Article 32 can be suspended during national emergency or not. So, one of the important debate in India, a landmark judgment has come on this point. So this is clearly mentioned in Article 359. So, according to Article 359, President of India by an order can suspend any of the fundamental right except the rights mentioned in 20 and 21. That means what? All the rights mentioned in the list of Part 3, that is from Articles 14 to Articles 35. Alright, President of India has the power to suspend any of the fundamental right except these two rights, that is 20 and 21. 20 deals with protection in respect of conviction in certain offences. Protection, in respect of conviction in certain offences, that is Article 20. Article 21 is protection of life and liberty. So, except these two rights, any other right can be suspended, which also includes the rights mentioned in Article 32. What are the rights given in Article 32? Enjoy the constitutional remedies, right to enjoy constitutional remedies, that is using of writs. That means, what is the purpose of writs? The purpose of writs is to safeguard fundamental rights. The purpose of writs is to safeguard the rights whenever they are restricted. Now, what does this Article 359 says? If you take this Article 359, it says that President has the power to restrict any fundamental right, which also includes Article 32. That means what? The individual has no right to move to courts to enforce, to enjoy these remedies. That is, the individual cannot claim constitutional remedies. Right? Listen to me. Very important debate. The individual cannot enjoy constitutional remedies whenever there is national emergency. Alright, now if you take article 21, now there is a link between these. What is this article 21 says? Article 21 states that there shall not be arbitrary restriction on life and liberty of individuals. That means the life and liberty of individual cannot be restricted arbitrarily. Now if there is a restriction on life and liberty of individual, what individual should do? He has every right to protect his liberty and life. He can go to whom? He can approach Supreme Court. On one hand, Article 30 has been restricted, but at the same time, what does Article 21 says? Every individual has the right to protect their own life and liberty. Every individual has right to protect their life and liberty. Right? But Article 32 states that the individual has no right to move to courts during national emergencies. So one of the important judgments were given on this issue. That is, we know that during Indira Gandhi time there was a national emergency imposed, right? And the rights of individuals, they are being restricted during this national emergency. The issue went to Supreme Court, right? Which is popularly called as Shivakant Shukla versus ADM Jabalpur case, right? This issue of approaching courts for the sake of protecting life and liberty, approaching courts for the purpose of enjoying the constitutional writ given under Article 32. So this was popularly debated in a landmark case, right, called as Shivakant Shukla case. Shivakant Shukla versus ADM Jabalpur. Shivakant Shukla versus ADM Jabalpur case. Additional Divisional Magistrate. Right? ADM Jabalpur case. Right? In this case, Supreme Court said that the individual has no right to claim habeas corpus. Right? In this case, Supreme Court held that the individuals has no right to claim habeas corpus during when national emergency is imposed. When national emergency is imposed. That means what? Supreme Court said that the individuals have no right to move to courts. The individuals have no right to move to courts for the purpose of enforcing constitutional remedies, for the purpose of enjoying constitutional writs. అంటే ఎప్పుడైతే నేషనల్ ఎమర్జెన్సీ ఇంపోజ్ అవుతుందో రైట్ అప్పుడు రైట్ ప్రెసిడెంట్ కెన్ రిస్ట్రిక్ట్ ఎనీ ఆఫ్ ది ఫండమెంటల్ రైట్స్. అది ఆర్టికల్ 32 కూడా కావచ్చు. అంటే ఆర్టికల్ 32లో మెన్షన్ చేసిన విట్స్ కూడా రిస్ట్రిక్ట్ చేసుకోవచ్చు అని చెప్పింది. దట్ మీన్స్ వాట్? రైట్, వెన్ ఎవర్ అ నేషనల్ ఎమర్జెన్సీ ఇస్ ఇంపోజ్డ్, ద ఇండివిజువల్ హ్యాస్ no right to claim these constitutional remedies. Right, the individual cannot claim remedies, the individual cannot go to courts and cannot ask writs. Courts ki velladaniki veelu ledu, remedies ni adadaniki veelu ledu, writs ni adadaniki veelu ledu. Right, this is what said by Supreme Court in Shivakant Shukla versus ADM Jabalpur case. That means what? There is no guarantee for life and liberty of individuals. Ante kada, కోర్ట్స్ వెళ్ళడానికి లేదని చెప్తున్నాము. రైట్, కాన్స్టిట్యూషనల్ రెమెడీస్ని ఎంజాయ్ చేయడానికి వీల్లేదని చెప్తున్నాము, విట్స్ని తీసుకోవడానికి వీల్లేదని చెప్తున్నాం. దట్ మీన్స్ వాట్? ద ఇండివిజువల్ హ్యాస్ నాట్ బీన్ గ్యారంటీడ్ ఎనీ ఆఫ్ దిస్ లైఫ్ అండ్ లిబర్టీ. దిర్ ఇస్ నో గ్యారంటీ ఫర్ లైఫ్ అండ్ లిబర్టీ ఆఫ్ ఇండివిజువల్స్. దట్ ఈస్ వాట్ ది అవుట్కమ్ ఆఫ్ దిస్ what you call Shivakant Shukla versus ADM Jabalpur case. Right, that is the reason why this is regarded as one of the worst judgment given by Supreme Court in its history. Because what is the purpose of Supreme Court? Whether the purpose of Supreme Court is to protect the life and liberty or to restrict the life and liberty? What is the ultimate role of Supreme Court? the role of Supreme Court is to act as guardian. The role of Supreme Court is to act as guardian and watchdog of fundamental rights. But what the Supreme Court has said here, it said that the individual cannot come to courts and can ask remedy. They cannot come to courts and they cannot ask any kind of remedy. So this is regarded as the worst judgment in the history of Indian judiciary. And this judgment was reversed by Supreme Court in Maneka Gandhi versus Union of India case. Alright. Supreme Court has reversed this judgment. Supreme Court has reversed the judgment in Maneka Gandhi versus Union of India case. So in this case, Supreme Court held that. In this case, Supreme Court held that. Alright, it held that even during emergencies, every individual has the right to move to courts for the purpose of protecting their life and liberty. Alright, that means during emergencies, every individual has the right to enjoy the writ of habeas corpus. Alright, so the individuals have the right to enjoy, every individual has the right to enjoy the writ of habeas corpus. Habeas corpus, where the purpose of habeas corpus is to protect life and liberty of individual. Right? I will talk about the literal meanings of these writs later, but remember, the Supreme Court in Maneka Gandhi versus Union of India case said that every individual has the right to move to courts and can seek constitutional remedies even during emergencies. That means the individual has the right to enjoy the writ of habeas corpus even during emergencies. Emergency vidinchina sare, right? Habeas corpus writ ni right use chesukovachu, right? The individuals have the right to use this habeas corpus, and Supreme Court cannot deny this right. The Supreme Court has no power to deny this right, because ultimately the Supreme Court is a guardian and watchdog of fundamental rights. Right? So though all other writs can be restricted, remember, other writs can be restricted, but the writ of habeas corpus cannot be restricted. Mandamus can be restricted, prohibition, certiorari, quo warranto, all other writs can be restricted, but the writ of habeas corpus cannot be restricted even during emergencies. So this is the landmark judgment given in Maneka Gandhi case. Alright. So once again I repeat, the fundamental rights can be restricted during national emergencies. According to Article 358, the rights which are mentioned in Article 19 will be automatically suspended. Apart from this Article 19, according to Article 359, President of India by an order can suspend any of the fundamental rights except the rights mentioned in 20 and 21. It implies that the rights mentioned in Article 32, the writs mentioned in Article 32 can also be restricted. So initially in Shivkant Shukla case, Shivkant Shukla versus ADM Jalpur case, Supreme Court held that during national emergency, whenever emergency is imposed, the individual has no right to claim constitutional remedy. That is, the individual has no right to come to courts and seek remedies. Alright, that is, there is no guarantee for rights during emergencies. So this is what said by Supreme Court in Shivkant Shukla case. But later in Maneka Gandhi versus Union of India case, Supreme Court held that every individual is guaranteed of their life and liberty even during national emergency. That means the individual have every right to enjoy the constitutional remedy of habeas corpus even during national emergencies. That means the writ of habeas corpus cannot be restricted during national emergencies. Right? So this is one feature of fundamental rights. That means fundamental rights can be restricted. No? They can be restricted. That is what I am saying. except habeas corpus, habeas corpus, other writs can be restricted. The writ of mandamus, prohibition, certiorari, quorum, they can be restricted, but habeas corpus cannot be restricted. So whenever national emergency is imposed, habeas corpus is available to every citizen, but other writs are not available. రైట్, హబియస్ కార్పస్ని ఎప్పుడైనా సరే ఎంజాయ్ చేసుకోవచ్చు, అది అవైలబుల్లో ఉంటుంది, యూజ్ చేసుకోవచ్చు. కానీ మిగతా రిట్స్ ఏవైతే ఉన్నాయో అది ఎమర్జెన్సీ విధించినప్పుడు యూజ్ చేసుకోవడానికి వీలు లేదు. రైట్, ఐఎమ్ క్లియర్ అబౌట్ దిస్. రైట్, సో విల్ డూ వన్ థింగ్, ఐల్ టేక్ అ బ్రేక్ హియర్ ఆన్ దిస్ పాయింట్, అండ్ ఆఫ్టర్ ది బ్రేక్ విల్ మీట్ అగైన్. A break of 5 minutes. So I was talking about what you call restrictions on fundamental rights. That is, fundamental rights are not absolute, they can be restricted. Alright. So, and they are enforceable. Remember, both Supreme Court and High Courts have been given the powers to enforce fundamental rights. Right? Remember, another feature is both Supreme Court and High Courts, they have been given power to enforce fundamental rights. Right? Okay. So, Supreme Court under Article 32, whereas High Courts under Article 226. So, normally, right, the aggrieved individual, aggrieved means the affected individual. That means the individuals whose rights are violated, they are required to approach High Court first. That is, before approaching High Court, before approaching Supreme Court, the affected individual, the aggrieved individual should approach High Courts, because even High Courts have the power to issue writs. And remember, the writ jurisdiction of High Court is more when compared to the writ jurisdiction of Supreme Court. Right? The difference between High Court and Supreme Court in their writ jurisdiction is, it is injunction. Right? So, High Courts can issue the writs of habeas corpus, mandamus, prohibition, certiorari, quo warranto, and along with that it is injunction, that is another writ that is issued by High Courts. So, the writ of injunction is exclusively available for High Courts, but not for Supreme Court. So, constitutionally speaking, it is Supreme Court and High Courts which are given the power to issue writs. But coming to the subordinate courts, that is district courts or other subordinate courts, actually they are not conferred the power to issue writs. Right? Constitutionally they are not given the power to issue writs, but right, if required by a law of Parliament, right? If required by a law of Parliament, these subordinate courts can be empowered. Right? The subordinate courts, if required, these subordinate courts can be empowered to issue the writs. Right? If required, these subordinate courts can be empowered to issue writs by a law of Parliament. Right? Whereas Supreme Court and High Court, they are given the powers directly by the Constitution. Right? So, that is the writs of the writs issued by Supreme Court and High Courts. Right? So, if an individual directly approaches Supreme Court, what Supreme Court will direct is, right, it will direct the individual to go to High Courts first and then come to Supreme Court. Direct to Supreme Court kelna gaani Supreme Court writs issue ivvadu. Right? What it will do is, it will direct the individual, individual to move to High Courts first and then come to Supreme Court. Right? By way of right, you can first, normally it is it is to High Courts first and then go to Supreme Court. In case of writs, in case of enforcement of writs, right, the normal practice, the actual practice is first approaching High Courts and then approaching Supreme Court. Right? So, this is the issue is. This is the issue. Okay. So, these fundamental rights can be restricted, right? They are enforceable, they are guaranteed, right? So, whenever national emergency is imposed, there is an impact on fundamental right. As I said, according to Article 358 as well as Article 359. Both Article 358 and Article 359 deals with the impact of national emergency on fundamental rights. Impact of national emergency on fundamental rights, right? So, this is the point. Right. So these are some of the features, and remember these fundamental rights, they are classified under in our constitution. It is for our convenience, that these fundamental rights are classified. So originally we had 7 types of fundamental rights. Originally we had 7 categories of fundamental rights, but now it is only 6 categories. So let us talk about these different categories of fundamental rights. Let me talk about different categories of fundamental rights. Say the first category is right to equality. Right to equality, which are mentioned in Articles 14 to Articles 18. Articles 14 to Articles 18, they aim at promoting right to equality. Next, right to freedoms. Right to freedoms, which are mentioned from Articles 19 to Articles 22. Third one, rights against exploitation. Rights against exploitation, which are mentioned in Article 23 and Article 24. Right. Similarly, right to religious freedoms. Which are mentioned in right to religious freedoms, which are mentioned from Articles 25 to Articles 28. Next one, fifth category, it is cultural and educational rights. Cultural and educational rights, which are mentioned in Articles 29 and Article 30. Articles 29 and Article 30, they deal with cultural and educational rights. Originally we had right to property. Originally we had right to property, which is mentioned in Article 31. But remember, this right to property is totally deleted from the list of fundamental rights. Remember, it is removed from the list of fundamental rights by way of 44th Amendment Act. It is by 44th Amendment Act, this right to property is removed from the list of fundamental rights. Right. So now we don't have right to property. And the last right is right to constitutional remedies. Right to constitutional remedies, which are mentioned in Article 32 of the Constitution. Right. So these are different categories of fundamental rights that we have: right to equality, right to freedoms, rights against exploitation, right to religious freedoms, right, educational and cultural rights, and the right to constitutional remedies. Right. So these are different types of fundamental rights. Another important feature of fundamental rights in Indian Constitution is they can be amended. Right. Fundamental rights are amendable. Fundamental rights are amendable. They can be amended by using Article 368. These fundamental rights, they are amendable by using Article 368 of Indian Constitution. By using this 368. So these are different features of fundamental rights. These are different features of fundamental rights. Take down a question. Take down a question. Explain. Enumerate and explain. Enumerate and explain Enumerate and explain. Enumerate and explain the features of fundamental rights, which are enshrined in Part 3 of the Constitution, which are enshrined in Part 3 of the Constitution, which are enshrined in Part 3 of Indian Constitution. Right? Next question. Bring out the differences between fundamental rights, and other constitutional rights. Fundamental rights and other constitutional rights. Bring out the differences between fundamental rights and other constitutional rights. All right. So these are the questions on features. Right. Now let us talk about two important issues of fundamental rights. That is, one is the issue of restrictability of fundamental rights, and second one is the amendability of fundamental rights. One is the restrictability of fundamental rights, and second one is amendability of fundamental rights. Very important for mains. It is very important. Just listen to my class. And one point I want to say very clearly, the topics that we are discussing in the class, they are more than enough, right? Because when you see the question papers, you will come to know, right? The topics, the points that I am covering in the class, they are more than enough to clear exam. Restrictability of fundamental rights, right? And here this discussion you will not get in Indian polity by Lakshmikant. The topic, that is the issue that I am going to discuss now, the point that I am giving in this class now, you won't get them either in NCERT book or in Lakshmikant book, right? You can get this discussion from Introduction to Constitution by D.D. Basu. So whatever I am teaching in this class now, you can get it from D.D. Basu. So for one topic or for few topics, you need not read the entire textbook, or you need not purchase the entire textbook. So just focus on the class, right? Write running notes, particularly the case studies that I am going to discuss here. It is very important, right? So just now we have concluded that fundamental rights are restrictable. Just now we have said that fundamental rights are restrictable, right? So now let us go into these issues. All right. The government by a law can restrict fundamental rights, right? This issue has come, right, because of, right, restrictions imposed on right to property. Restrictions imposed on right to property. There are two important issues that went in India in the early days of Constitution, right? Particularly in between 1950s to 1960, right? Two rights were restricted, two fundamental rights were restricted, right? One is the the right of Article 31, that is the right mentioned in Article 31, which deals with right to property. Other one is Article 15 of Constitution. One right is Article 31 and the other right is Article 15, prohibition of discrimination. Government came with a new concept called as reservations. Reservation laws were made, right? So reservations right, which are seen as a violation of Article 15. The reservations that are given, the reservation laws that are made by the governments, they are seen as violative of Article 15. So these two issues, that is right to property and the reservation laws, they have violated, they have restricted the fundamental rights. So the entire debate on went on these two issues, right? And remember another important point, by First Amendment Act, right, the government of India has added 9th schedule to the constitution. Originally we had only 8th schedule, but by First Amendment Act, 9th schedule was added to the constitution, right? And all the laws dealing with right to property, all the laws restricting right to property as well as providing reservations, they are inserted in this 9th schedule. So land reform laws, alright, one is land reform laws, that is laws relating to land reforms. Other one is the laws relating to reservations, right? So both these laws they have restricted fundamental rights, right? And if you take this 9th schedule, right, while inserting 9th schedule, a constitutional amendment was made, right? Remember, this 9th schedule was added to constitution by constitutional amendment and said that all those laws which are inserted in 9th schedule, అంటే 9th షెడ్యూల్లో ఉన్న ప్రతి లా, 9th షెడ్యూల్లో ఇన్సర్ట్ చేసిన ప్రతి లా, రైట్, కోర్టుల్లో క్వశ్చన్ చేయడానికి వీలు లేదు అని చెప్పింది, రైట్. All those laws which are inserted in 9th schedule, they are made immune. All those laws which are inserted in 9th schedule, they are made immune from judicial review, right. So these laws, they are made immune. Immune means what? They cannot be questioned, right. They cannot be questioned in courts, they cannot be questioned in Supreme Court. The laws which are inserted in 9th schedule, they are not allowed for questioning in Supreme Court. So that is what 9th schedule says, that is what a law made by Parliament, alright. And this 9th schedule, these land reform laws, these reservation laws, all they went for challenging in Supreme Court, right. So initially it was in Shankari Prasad versus Union of India case. Shankari Prasad versus Union of India case. So all such laws, that is land reform laws, right, laws affecting right to property, laws restricting right to property. Remember, this land reform laws, it has restricted right to property, and the one whose property is been restricted and the one whose property is taken by the government, they went to Supreme Court. వాళ్ళైతే కాంగ్ ఉండరు కదా, వాళ్ళ ప్రాపర్టీ పోయింది కాబట్టి దే వెంట్ టు సుప్రీం కోర్ట్, రైట్. ద ఫస్ట్ ఇష్యూ కేమ్ ఇన్ శంకరి ప్రసాద్ వర్సెస్ యూనియన్ ఆఫ్ ఇండియా కేస్. In this case, Supreme Court upheld the power of Parliament to make laws restricting the rights of individual. That means the Supreme Court has supported the government. Supreme Court upheld the power of Parliament to make laws restricting the fundamental rights. That means what? In Shankar Prasad case, right, Supreme Court upheld, Supreme Court said that, right, Parliament has the power to restrict fundamental rights. So, the restrictions on fundamental rights are being justified even by Supreme Court. Right? Same thing was said by Supreme Court in, right, Sajjan Singh versus State of Rajasthan case. Right? Shankari Prasad case. Alright, Sajjan Singh case, Sajjan Singh versus State of Rajasthan case. ఇవన్నీ ఎగ్జామ్ గుర్తుపెట్టుకోవాలంటే అన్నీ గుర్తుపెట్టుకోవాల్సిన అవసరం లేదు. వెన్ యూర్ రైటింగ్ ఎగ్జామ్, use 2 or 3, not all the case studies. For your information, I am giving all these cases, but in exam, write 1 or 2. You are not writing a legal exam, first thing. You are writing a general studies exam. It is UPS exam, but not a law exam. You need not go to all the case studies that are required. Alright, only quote the landmark cases. One thing that is you need to do is, don't try to remember all the case studies. My duty is to give the case studies, but for you, only write the landmark cases. Right? If you are unable to remember all these cases, leave it. Don't waste your time. Don't waste your time and don't waste your energy in remembering all these cases. But remember the landmark cases. So whenever there is a landmark case, I will highlight it. Just now I was talking about what you call Menaka Gandhi case, and I said it is a landmark case. You need to remember it. Right? So both in Shankar Prasad case as well as in Sajjan Singh case, Supreme Court upheld the power of Parliament. Right? It has upheld the power of Parliament to amend, to restrict and amend the fundamental rights. Right? And because of this, right, from 1951 to 1967, right, there were numerous cases which filed in Supreme Court on the restrictions of fundamental rights. The cases got piled up, right, the petitions got piled up in Supreme Court, right. So Supreme Court got vexed by these kind of petitions because governments went on restricting the fundamental rights, right. Government went on restricting the right to property, and it has restricted the what you call rights mentioned in Article 15 by providing reservations. And Supreme Court already said that in 1951 itself, Supreme Court held that Parliament has the power to what you call restrict and amend the fundamental rights. But still the cases were being filed in Supreme Court. It was in Golaknath versus State of Punjab case. It was in Golaknath versus State of Punjab case. Supreme Court has brought the halt. Alright. A new turn took place in Golaknath versus State of Punjab case. Right. Golaknath versus State of Punjab case. But remember, before this, right, before this issue, there was another issue. Alright. So Supreme Court has upheld the power of Parliament to impose restrictions. But what kind of restrictions can be imposed by the state? What kind of restrictions can be imposed by the state? Alright. So Supreme Court held that. Supreme Court said that state can impose only a reasonable restrictions. Alright. Supreme Court in A.K. Gopalan. In A.K. Gopalan versus State of Madras case. In A.K. Gopalan versus State of Madras case, Supreme Court held that, right, only reasonable restrictions can be imposed. Right? For the first time, Supreme Court has brought this concept of reasonability. So before this case, there was no concept of reasonability. Right? So it was in this A.K. Gopalan case. The importance of this A.K. Gopalan case is that it was in this case for the first time Supreme Court has brought the concept of reasonability. Right? It has introduced the test of reasonability. It has introduced the test of reasonability. Right? So, every restriction that is imposed on the rights of individual should be reasonable in nature. Right? That is, they will be called as reasonable. They will be called as reasonable if the objective that is sought is achieved. Alright, so the government has the power to impose restrictions. అంటే దేనికైతే మనం ఎందుకోసమైతే మనం రిస్ట్రిక్షన్స్ ఇంపోజ్ చేస్తున్నామో ఆ ఆబ్జెక్టివ్స్ అచీవ్ అయినప్పుడు మాత్రమే ఆ రిస్ట్రిక్షన్స్ అన్నవి రీజనబుల్ అనబడతాయి. అంతే కదా, అనుకున్న ఆబ్జెక్టివ్స్ అచీవ్ అయినప్పుడే దే ఆర్ కాల్డ్ యాజ్ రీజనబుల్. ఒకవేళ అచీవ్ కాకపోతే they won't be called as reasonable. That means there should be a clear nexus between the kind of restrictions and the objective sought. Right? There should be a clear relation. So, while talking about this test of reasonability, Supreme Court clearly said that there should be a clear relation between nature of restrictions. There should be a clear relation between nature of restrictions and the goal to be achieved. There should be a clear relation between nature of restrictions and goals to be achieved. There should be a clear nexus. ఎందుకోసమైతే మనం ఆ రిస్ట్రిక్షన్స్ ఇంపోజ్ చేస్తున్నామో ఆ గోల్ అచీవ్ అయి ఉండాలి, అప్పుడే దే విల్ బి కాల్డ్ యాజ్ reasonable. Right? Now here there is one highlight. The highlight is, though Supreme Court said that the restrictions that are imposed should be reasonable, Supreme Court took a narrow view. Supreme Court took a narrow view in defining this reasonability. That is, Supreme Court has confined itself to the acts of government, to the acts of executive. So, while talking about reasonability, in A.K. Gopalan case, Supreme Court took a narrow view. It took a narrow view. That is, it has confined, right, itself only to the acts of executive. Acts of executive, that is the acts of government. That means what? Right? Supreme Court said that every restriction that is imposed by the government should be reasonable in nature. The acts of government should be reasonable. So there is no legislature used here. The role of legislature, the laws made by legislature is not brought into this discussion. Right? The discussion is restricted only to the acts of government. Right? Supreme Court held that the restrictions will be called as reasonable. The restrictions will be called as reasonable if every restriction that is imposed by the government is according to the procedure established by law. Right? So, every restriction that is imposed by government should be according to what? It should be according to procedure established by law. It should be according to procedure established by law. So, which is clearly mentioned in our constitution. In our constitution, it is in Article 21. It is in Article 21. It is clearly said that every act of the government, every act of the executive should be according to the procedure given by law. It should be according to the procedure given by law or procedure established by law. Right? So here Supreme Court gave importance to procedural aspects. Supreme Court gave importance to procedural aspects. So the restrictions will be called as reasonable. The restrictions will be called as reasonable if the restrictions are according to the procedure given by law. అంటే చట్ట ప్రకారం నడుచుకుంటున్నారా లేదా, చట్ట ప్రకారమే రిస్ట్రిక్షన్స్ ఇంపోజ్ చేసిందా లేదా, అంటే ఇంపోజ్ చేసిన ప్రతి రిస్ట్రిక్షను చట్ట ప్రకారమే అయి ఉండాలి. ఎవ్రీ రిస్ట్రిక్షన్ దట్ ఈస్ ఇంపోజ్డ్ షుడ్ బి అకార్డింగ్ టు ది ప్రొసీజర్ గివెన్ బై లా. It is then they will be called as reasonable. So this is called as procedural reasonableness. We can call it as procedural reasonableness. We can call it as procedural reasonableness. All right. Now I'll say I'll give one example. Very funny example. All right. So don't take it too seriously. Think that we have a law in this class. In this class we have made a law that anyone who has failed to clear prelims exam, they should be thrown from the 4th floor of this building. This is a law made in this institution. That means what? There is a law and there is a clear punishment. And punishment is even for implementing this punishment there is a clear procedure. It is not hanging till death, it is not stabbing, it is not shooting. How? What is the punishment? Throwing from the 4th floor. సస్తే చావండి లేకపోతే లేదు. కానీ పనిష్మెంట్ ఏంటిది? 4th ఫ్లోర్ నుంచి తోసేయడం, అది పనిష్మెంట్. అంటే మనకంటూ ఒక కరెక్ట్ ప్రొసీజర్ ఉంది, ఒక లా ఉంది, ఆ లాలో ఒక ప్రొసీజర్ ఉంది. ఇఫ్ యూ ఫెయిల్ టు క్లియర్ ప్రిలిమ్స్ దెన్ ఐ విల్ త్రో ఫ్రమ్ ది 4th floor. Now whether my act is reasonable or not, whether the restriction imposed on you is a reasonable restrictions or not. Can you call my restrictions as reasonable restriction? Why it is reasonable? Cheppandi. Why it is reasonable? It is according to the law and it is according to the procedure established by. I am not bothered about law. I am not bothered about the law. I am bothered about what? Whether I am following the law or not. And even you are bothered about what? Whether law is followed or not. So ikkada pratidi chatta prakaram jarugutunda leda, whether everything is according to law or not. So that is what we are concerned with. So we are concerned with the procedure established by law. So Supreme Court said that. Now can you justify these kind of laws? Do you think that a law providing a punishment, which provides a punishment of death for failing to clear prelims, do you justify it? Do you justify this punishment? Do you justify this punishment that is given by law? Prelims కాకపోతే, ప్రిలిమ్స్ తప్పితే, రైట్, చంపడం అన్నది, రైట్, 4th floor నుంచి తోసేయడం అన్నది రైటా రాంగా? అదొక జస్టిఫైడ్ లానా కాదా? కాదు. చిన్న తప్పుకి గింత పెద్ద శిక్షనా సార్? తప్పేది చిన్న తప్పది. ప్రిలిమ్స్ అవుతా లేకపోతే లేమో గ్యారంటీ ఉందా? రైట్. Yesterday I have given, there was an interview given by the former chairperson of what you call Punjab Public Service Commission, who has talked about reforming UPSC. Right? He was talking about the number of attempts. Right, and the age limit, right, in taking the civils exam. He felt that the success ratio is very less and most of the people are wasting their life, right, in, yes sir. So you feel that most of the people are wasting life, then why you are coming into civils? Right, you are greedy, that is the reason why you are in civils. You are greedy for what? ఎన్ని సంవత్సరాలైనా ఏం కాదు సార్, మేము కొట్టి తీడతాం. Alright, we are not bothered about the time. We want to clear service. Enduku? Because we want money. We want money and power and recognition. So the former chairperson of this Punjab Public Service Commission, he was talking about the kind of changes required in UPSC. If you ask me, definitely there should be changes in the syllabus of UPSC. Because if you take the prelims syllabus that we have today, right, it is not meant to choose the right candidate into civil services. Right? After coming into services, we have seen many of these officers are facing public criticisms. They are facing public criticisms and moreover, they are facing criticisms from courts. Courts are blatantly criticizing them. The young IAS officers, they are being criticized by the courts as well as there are many videos in Facebook. I'm seeing these videos in Instagram, in Facebooks, right? Courts are punishing these young IAS officers. Now, what is the reason for this? Corruption cases, misuse of power, misuse of authority, misuse of public money. Now, what is the reason for all these things? It is, if you ask me, the kind of selection procedure particularly adopted in prelims. Now, what kind of qualities are being tested by CSAT? What is the point in having a qualifying exam there? If you ask me, the marks that are required to get qualified in CSAT is 66 marks. Now, to get 66 marks, what is the need of attempting 80 questions? Just by attempting 40 questions, if you are good in 40 questions, you can get selected there. Now, what kind of qualities you are selecting? You are selecting the mechanical abilities, but not the kind of abilities that are required for public services. CSAT is an unnecessary paper. Earlier, we used to have social sciences. In prelims exam, we used to have an optional subject. And the weightage of optional subject is more when compared to general studies. And subjects like sociology, political science, public administration, right, which make you to learn many things about state and society and the people. It is these kind of subjects which should be introduced in prelims. People should have this kind of knowledge. And coming to the scores in optional subjects in mains, right, I have seen people, one of the candidates who went for 3 times interview. Last year he got 276 in public administration, now he got about 258. He was crying. He thought of getting rank this year, but he could not make it out. Now, what is the reason for lower marks in optional subjects? Because hardly a candidate spends 2 months of time during for mains in optional. That is, hardly a candidate spends 2 months on optional subjects to revise. Nothing more than that. Then how can you expect more marks in optional subject? If you take GS, you prepare for prelims, you prepare for mains. Almost all you spend 8 to 10 months on GS. But coming to the time that you spend on optional subject, hardly. If you take coaching, it is 4 to 5 months or 6 months. And the time gap between your coaching and this mains exam, almost a gap of 1 year. And in this 1 year, you will forget everything. In this 1 year, you will forget everything. And you will freshly start optional only after your prelims results. The candidate starts optional preparation only after prelims results, or at most 10 days before the results, where hardly you will get 2 months of time. So, what will you read, what will you revise, what will you write in optional subject in these 2 months? And how can you expect more than 300 marks? Optional subjects, social sciences gives us the knowledge to understand the society. Only when you have this knowledge, you can be a better public servant. But these kind of qualities are not tested in prelims. So, if UPSC want to bring changes, changes should be in that area. Changes should be brought in prelim syllabus. Right? So, it is not the mechanical qualities, it is the qualities that are required for public servants. That is understanding society, the people, right? The changing form. So, all this you can know only when a candidate has a knowledge of social sciences, but it is been undermined. Alright. So, that means if you fail to, that is the case of providing punishment, excessive punishment. Killing a person for failing to prelims is an excessive punishment. So, that means what? What the reasonability should be called as? Right? When the restrictions will be called as reasonable? Only if the procedure is followed. Can we call these restrictions only if the procedure given by law is followed? Procedure follow aithe maatrame reasonable hota ya? Will they be called as reasonable if only this procedure is followed? What about the content of law? If you take the example, if you take the content of our example, if you take this law that is used, the content of that law, where it is justified content, the content of the law, the subject of the law is unjustified. So, not only the procedure, but even the law that is used should be just and fair. right? So reasonability will be the restrictions will be called as reasonable. The restrictions will be called as reasonable only if the law that is used is just and reasonable, not just by following the law, not just following the procedure given by law, even law that is used, the subject matter of that law, the substance of the law, the subject matter of law or the substance of law should be just and fair. When you call them as just and fair laws, when the restriction imposed is not excessive, right? We can call them as just and fair when the restrictions imposed, are not, what you call excessive nature. They are not excessive in nature. That means there should be a parity. There should be a parity between the restriction imposed as well as the objective. Right? The law should be just and fair. So Supreme Court has brought these elements of justness and fairness of the law in Menaka Gandhi case. Right? In Menaka Gandhi case, Supreme Court said that every law that is used to impose restrictions on the right and every law that is used to impose restrictions on rights of individuals should be just and fair. So Supreme Court has followed America's doctrine of due process of law. Supreme Court has followed, right, the America's doctrine of due process of law. So this due process of law says that every law that is used should be just and fair. Right? In A.K. Gopalan case, Supreme Court restricted only to the acts of executive. But now in Menaka Gandhi versus Union of India case, in Menaka Gandhi versus Union of India case, in this case, Supreme Court said that every law that is used, so not only acts of executive but also the laws made by legislature, right? Even the laws made by legislature should be just and fair. Right? The laws made by legislature should be just and fair. So this is what said by Supreme Court. Right? That means Supreme Court took a broader view. Supreme Court took a broader view in Menaka Gandhi case. In A.K. Gopalan case, it was narrower view. Now it is a broader view. It is broader because not only the acts of executive are covered, but also the laws made by legislature. And right, that is every law that is made to impose restriction should be just and fair. Right? So this is the debate on restrictability of fundamental rights. So fundamental rights are restrictable. Only reasonable restrictions can be imposed. Reasonable here means, right, following the procedure given by law. At the same time, the law that is used should be just and fair. Am I clear about this? Right? Take down a question on this point. This was a question asked in last year Group 1 mains exam, UPSC Group 1 mains exam, but it was asked many times in UPSC. Right? Discuss the debate on restrictability of fundamental rights. Discuss the debate on restrictability of fundamental rights. Restrictability of fundamental rights by using Supreme Court judgments. Alright. So this is about the issue. Alright. So for now I'll stop the class here, and before winding the class, let me sum up what we have discussed today. Right. So today we start our discussion with Citizenship Amendment Act. Right. So then we had moved into the topic of fundamental rights, where we have discussed different features of fundamental rights. Then we have talked about the issue of restrictability of fundamental rights. So these are the topics that we have discussed in today's class. All right. The next class will be on Tuesday. All right. So tomorrow it will be exam, Sunday holiday, and Monday is holiday. There won't be class on Monday. The next class will be on Tuesday. All right. So hopefully, all right, I expect you to write exam tomorrow. All right. So don't, what you call, get frightened. భయపడదు ఎగ్జామ్ అంటే. మీరు ఎంత నిర్భయంగా ఎగ్జామ్ రాస్తే అంత తొందరగా సక్సెస్ ఉంటుంది. రైట్. ఓకే దెన్ విల్ మీట్ ఇన్ టుమారోస్ క్లాస్.